I'm RG Skadberg, attorney with CCSK Law, where we do simplify the law for you. This is now what? What to do when someone dies. People have heard they need a will. They don't necessarily know what that means, and they don't know really that a lot of times wills don't get used when someone dies. Probate in Indiana is an administrative process after someone dies. If after that person dies, they have more than $50,000 in their name, his or her name, after they die. Now, it's important to understand you could have $1 million in your name right up to the point when you die, but based on how it's owned, beneficiary statements, trusts, all sorts of different things, when you die, there's this little magic moment where non-probate transfers happen and joint ownership moves a property out of that person's name. So you could have $1 million, but after you die, you have nothing in your name. And that goes to point first video. We don't know what's in the estate, or we don't know whether the estate's solvent or not. So we don't pay creditors thinking you're going to get paid back from the estate. So, but that to that end, in Indiana, under our current law, this is November of 2019, they keep threatening to change this, but there's a lot of attorneys that make a lot of money in probate, so I think it's an uphill battle. Also, the state itself needs to have probate happen so it can get paid back. As I referenced, if you're 55 and older, you have to tell the state when someone dies so they can make a claim against the estate. So there's a couple things that are going to keep it where it is for now. We'll see what happens. So $50,000 in your name. Maybe the house that someone lived in was only in his or her name. And the house itself was worth $100,000 net, after paying off a loan. Maybe someone has an expensive car, maybe money in the bank. I've had situations where they didn't fill out a life insurance policy properly, and since they didn't have a beneficiary, it bounces back into the estate. Any circumstance where there's a countable asset or assets that add up to more than $50,000, then the state wants to be involved in that process, and we take it through the court where the person passed, in the county where the person passed. So that's what triggers probate. Now, there's a couple of different types of probate. There's unsupervised and supervised. Unsupervised is most common, and it is where we go to the court, we open the estate, we have somebody appointed, and then we go off and we do the estate stuff. And then at the end, we report back to the court that everything was done properly, and we want the court to sign off on it being closed, and that's unsupervised. In that circumstance, where I mentioned in the first video, that is where my base price comes from. We're doing work outside of court. We don't have to be in court every time we do something, so it's much more efficient. I can charge less. We get it done. Supervised means that the court's going to be involved in every decision made, whether something's going to be sold, what the attorney's fees are going to be, how the creditors are going to be paid, the order of the creditors, all the different things. Everything you do has to go through court. A supervised estate is going to take a long time because it's not like the court is just sitting there waiting for us to drop in one day. If you have a court hearing, there is close to a month period of time from the date where you request the hearing before you can have the hearing. Part of it is you have to give notice of the hearing. Part of it is the court's calendar is very full. And the time it takes, now attorneys are going to charge every time we have to go to court and send out notice and prep all the hearing. Prep all the material for the court, prep all the material after we have that. So it gets to be very expensive. Sometimes supervised is necessary because people don't get along. And the only way that we're going to work through the estate process is to have the court involved. The big winner in that is the attorneys, or are the attorneys, because they are the ones that are getting paid for all this extra work. Even when you have a really big estate, which is where you may have some of these other circumstances, the attorneys are going to be charging a lot in fees because it's a very rigorous process. So unsupervised, supervised. The other component to define what type of probate we're going to have is whether there was a will or not. Now, everybody's been told they need a will. Don't necessarily know what that means to most people, but your will is basically your instructions to the court after you die. If you have a probate. Now, again, the reason why maybe not everybody needs a will is because we're not going to end up in probate. So we may, even someone has a will, we may not ever see it because we didn't go through probate because they didn't have assets to require it. So Intestate probate means that we had a will, last will and testament, right? So here's my instructions, the person I want to be in charge, here's what my family looks like, here's how I want things distributed in the process, okay? Whether I want the person to be bonded, there's a number of little things you put into a will to give instructions to the court. In one of my other campaigns or marketing information pieces, we talk about young families. If you've got children under 18, that's where we tell the court who we want to be the guardian. So the will is basically you put down some things, we formalize it, and we put it in the back, put it in a folder someplace. And if we ever end up in probate, we pull that will out and submit it to the court for the court to approve. If we don't have a will, we have what's called intestate probate. And the intestate probate, we look at the rules in the state laws of Indiana, and it says, okay, if a person doesn't have a will, here's what we would assume the person would have wanted. We still go to court. There's a population of people that the court may choose from to appoint as the personal representative, and that's the person who oversees the process. And then we work through the process. Ultimately, there's a distribution strategy that the state has assumed that the person would want. If you have children and a spouse, half the proceeds go to a spouse, half go to your children. If you don't have a spouse, it goes to all your children equally. So there's just some default things that they put in place. The thing I'll say about the personal representative, because that's not a term that a lot of people are familiar with. The term personal representative is the generic term. If you have a will, most people have heard the term executor. So the person, if you have a will, your executor is the person who executes the will's plan. Okay, if you don't have a will, then we have an administrator, the person that administers the estate based on the intestate rules. So that's where those two terms are. Umbrella, it's a personal representative, a PR. I use that term all the time, PR. That's the person who manages the affairs of the probate. So that's pretty much what probate is. I will tell you, there's another video I have out there. The fees that attorneys charge run a big gamut. There's a group of attorneys out there that say, let's look at the size of the estate and take a percentage of that as the fee. Doesn't matter how complicated it is. That's what they're gonna bill against. Now in a supervised, you have to get all your fees approved by the court, and so you're gonna have to, you get those after the fact. But the formula that I see used out there a lot, if you look at the rules, they're gonna say that here's the max fees to be charged on a supervised estate. Now the problem is I see a lot of attorneys just use that as their fee setting tool. I don't know why, but that's why, again, probate's very lucrative for law firms. So the other thing is sometimes people will do it just on a straight up hourly basis. Here's my hourly rate. Here's what I think approximately hours it will take to get through this process, give or take, and obviously we'll charge if it goes over more. Flat fee, that's my approach. Here's what most, more often than not, this is what probate takes for me to get done, and here's the fee for that, as I said in the other video. Uncontested, unsupervised, now you know those terms. Intestate or otherwise, intestate or testate, is $3,200. So that's my flat fee. That covers everything. So, and there are some caps on that if somebody comes back and starts making a mess of it, or if we end up with creditors and beyond a certain number, then we'll talk about what that means to the fee. But my base fee, most of my probates, uncontested, unsupervised, intestate or testate, $3,200. That covers most of the ones that I work on. So that's the probate. The process, the length of time, by the time we go through the process of, if we're going unsupervised, I'll just kind of assume that. We don't need a hearing to appoint a PR. We submit a document to open the probate and have the court appoint our nominated PR. There's consents signed by the heirs of the estate to agree to that person being appointed in an unsupervised capacity. If we can't get that, then we have to go to a hearing to appoint, which now delays the process. It may take us a month just to get the consent signed, get the paperwork back and forth, get it into the court, and get it signed. So there's a period of time from the starting point to the point where we actually have a PR who can start doing things. Once the PR is appointed, we have to publish the opening of the estate in a newspaper of general circulation in the county of the probate. So it runs in back-to-back weeks and says, hey, if you have a claim, here's the process you need to follow. We send out notice to creditors. We send out notice to the heirs to say the estate's opened and here's the person in charge. Here's the process you need to understand. We go through this 90-day period from the first date of publication where any creditor claim out there needs to be made, whether it's a credit card, the guy that was cutting the grass that thinks he needs to get paid, someone who just bubbles up and says that guy owes me money. They have to submit a claim to the attorney at that point, and at the end of 90 days, that claim period closes. Now, there's a couple who aren't limited by the 90-day period. The state of Indiana, I mentioned that earlier. If a person received Medicaid after the age of 55, I should say, Medicaid, SSI, SNAP, TANF, any of these, I think there's like 13 agencies that if the state put money out after the age of 55, it can make a claim against the estate. They are not limited by the 90-day period. So, it's important to understand if the person has received those funds potentially. And again, we get that notice out as quick as we can to the state. The federal, the IRS, the taxes, they also kind of live in their own world for claims. So they're not limited by the 90-day period. But your credit cards, other claims that might be against have to be put back in that 90-day period. Secured liens against property and judgments against property, they're already there. They have to get paid when that property's sold. There isn't a 90-day claim period on that. So that's the process. So after 90 days, we look and see what we've got. We do the math and figure out if we have anything with the state or someone that might be outside the 90 days. We've gathered assets during this period of time. We're gathering the property, closing bank accounts, opening an estate account, getting our hands around the stuff in someone's house. If we're listing a property for sale, we're getting it prepped and sold. That's all going in during this 90-day period of time. At 90 days, we can start to do the math on what we owe. We can start to do the math on what the assets are and see if we're going to be solvent. That is something that sometimes happens. The owed is greater than the assets, and we end up short. So then we have to do some other math and do some other things to work through that process. Once everything is collected, we know what our creditors are. We get our creditors paid. We calculate that there's some amount that's going to be distributed. We can send out, we're keeping an accounting of everything in, everything out. We send that out to the heirs and we say, okay, here's what we've done. That could be 9 months after we start. It could be a year after we start. Could be more. Just depends on where we are in the process and the complexity of the assets and gathering and such, or selling a property. That's what dictates time sometimes. At the point though, when we've got everybody paid, we can send out an accounting to the heirs and say, here's what we've done. Here's what's left. Here's what everybody's share is going to be. And if you agree to this, sign this consent, send it back. We submit that to the court to say, we've done all the work. We've got all the paperwork. We're just telling you it's all good. And everybody's in agreement based on these consents. If you want the paperwork, we can give it to you. Otherwise, we're asking you to sign off on the fact that we're going to start to close this. Once we get that signed, we can distribute to heirs at least a portion of what's due. We sometimes hold back to cover final taxes, some other expenses that might come up. We start a new 90-day period, and this is a claim period for someone that doesn't feel that they were done right. It has to be an interested party. They have to file a claim in the court and make a case for why they should be paid more, or why their payment wasn't right, whatever it might be. Or that they were left out and they shouldn't have been left out. So that there's a 90-day period for an interested party to file a claim. Has to be filed in court. That one doesn't go to the attorney. It has to be in court. And then we have a hearing to determine whether it's appropriate or not. So that's the process. If nothing happens, and more often than not it doesn't, we get to that 90-day period. We submit something to the court and say, we're good. Can you sign an order to close? We get an order to close, and it's done. To get that done in 6 months is just not possible. Because if you got 2 90-day windows and you're not starting for a month, you're already past that. But most of the probates I work on, we get wrapped in a year, maybe just after, depending on property and sale and such. So that's probate. Not everybody needs probate. We don't know if you're going to need probate until we go through the process of determining the value of an estate. We don't know what's going to be in the estate until we get a chance to start gathering information. So that goes back to the list of things. We don't know what we need to do until we can make that determination. So let's work through the process together as we see fit. And then if we don't have probate, there's an alternative means by which we can work through it called small estate administration. So that's a snapshot of probate. If you have additional questions, feel free to give me a call. Hope you'll get some additional information from the other videos and let me know if there's something I can do to help you through this process.